chronicling of documentation of RJM's 51514 conversation with clerk of the 7th Circuit Court of Appeals, Eric Frost. He informed RJM that, according to someone, a clerk had reviewed, was the verb he used, RJM's motion to rescind the filing restriction with the remission of 1 penny, and that reviewer had rejected the filing, according to Mr. Frost, on the basis that it wasn't a motion to rescind, because what was underlined in a declaratory character who was not apprehended as constituting a title by the individual who reviewed that. So the RJM then examined Mr. Frost and asked Mr. Frost, how can you claim that what is underlined and is in a third person, it's a declaratory statement, how could that be classed, how could it not be understood that that constitutes a title, given that underneath it there's a first to second person addressing, that is a petition from person A to person B in the form of a seeking of some form of consideration, whereas the title again is in a declaratory character. It's an abstraction. It's not, it's a definition of what it is that is sought in the petition that is addressed to, from one entity, Robert J. Moore in this case, to the entity of the court. So RJM then demanded an explanation as to how it could be justified to reject that petition. RJM then, and Eric said that there's no, the word rescind, there's no demand for the rescinding. RJM then read the motion to him and said, identify the word rescission in the title to the motion. And then Mr. Frost and RJM said, how could you claim that that version of rescission doesn't constitute the inclusion of the verb rescind, since it's a substantive that has been produced from the verb rescind? The substantive rescission is a substantive emanating from the verb rescind. He couldn't answer that question. So RJM then said, explained what constituted the notice of motion, the certificate of service, how those have been scratched out because RJM could not afford those, and demanded that that document be presented to a Article III judge, not rejected by a clerk who's not an Article III judge, because there's an issue of the excessive fine, the excessiveness of the fine, and the impossibility of RJM's paying that fine, which is then a legal issue. It's not an issue that can be resolved by the clerk. So the point is that that requires a judicial adjudication as to whether or not RJM is incapable of paying that fine, which then brings RJM under the protection of the axiom, the law cannot require the impossible. So RJM explained that, and RJM then inquired as Mr. Frost, who is the person that rejected it? And the only answer RJM got was the pro se manager. And RJM then sought further clarifications. He couldn't get that. RJM then demanded that Mr. Frost demonstrate how anything that would be declared to be surplusage could constitute a basis to claim that the whole document was fatally defective. RJM couldn't find any such thing, and RJM complained about the due process issue of there not being an adequately clear indication of what constitutes the number of words in a title, what would constitute too many words, what would constitute not enough words, and then RJM was demanding that the whole matter be resolved because RJM was claiming that it was totally unacceptable to reject that document based on the basis that Mr. Frost had presented to Robert J. Moore for the rejection whereof by a clerk. RJM can't remember what else went on, but he'll add anything to this recollection as he recalls more clearly. That conversation in the afternoon, about 4:45 p.m. on 5/15/14.